Morning. My name is Brian, and my number metric is 220DAT23F1802. And I am going to present about end of chapter for business law. Question 1. Elena, who career as a accountant for more than 2 decades, had been employed as the director of Tradex Berhad, an investment company. In discharging of her main duties, she is required to prepare the financial statement according to the basic standard guideline and framework. Lena, however, had negligently prepared such document where it involved a series of major misstatements and miscalculations. This would never not be expected from Elena, who has deemed to have a vast experience in practice. Following a huge loss and setbacks, the company had dismissed Elena and sued her for damages. Advised Elena accordingly. Good morning. The issue here is whether the company can sue Elena. The issue here is whether the
Hi, my name is Darren. Provision for the case is Section 165, Contract of Act. An agent is bound to conduct the business of the agency with as much skill as is generally possessed by persons engaged in similar business, unless the principal has notice of his want of skill. The agent is always bound to act with reasonable diligence and to use such skill as he possesses and to make compensation to his principal in respect of the direct consequences of his own neglect, want of skill or misconduct, but not in respect of loss or damage which is indirectly or remotely caused by neglect, want of skill or misconduct. The, the related case is Keppel against Weller, 1927. The defendant was employed by the plaintiff to sell his house. An offer was received by and accepted by the plaintiff, subject to contract. A few days later, a higher offer for the same property was made by X, but this offer was not communicated to the plaintiff. A written contract of sale between the plaintiff and the first offeree was duly signed. The court that held the defendant was liable to the plaintiff for the difference between the two offers. The inference is that the agent must disclose everything coming to his contract which is likely to influence the principal in the making of the contract.
Hello, my name is Marcus Ryan. I'm the third presenter. Okay, the application for this case is Lena, who has more than 2 decades experience as an accountant, should have done her work more efficiently, but because of her negligence, the company suffered loss. So, the company has the right to dismiss her from her position, and the company has the right to take legal action to sue her under Section 165 of Contract Act 1950, and the related case is Keppel against Wheeler, 1927. Elena must give cooperation and give all related information about her work. Failure to follow the proceed may receive legal consequences. The conclusion for this case is yes, the company can sue Elena because the cause of for the loss and setback. In Section 165 of Contract Act, agent must use his skill and be diligent about the interests of his principal. Agent must make sure that when he is acting on behalf of the principal. It is important for him to be careful.
Question 2. Eden wanted to sell his Range Rover to any interested party in order to raise his personal fund. Through any advertisement, he had coincidentally met his old friend Danny on 24th April of 2024, who agreed to buy at a price of 750k. Convinced that Danny will settle the payment in full on 1 May 2024, May had eh, Eden had immediately transferred the car to Danny on the same day. Unfortunately, there was no any payment effected on 1 May 2024, and Eden therefore realized that he had been cheated. Eden tried to claim his car from Danny on the next day, but only to discover that it had been sold to Lisa, a third party who bought it in a good faith. Advised Eden accordingly. The issue here is whether Eden can claim his car.
Provision for question 2 is section 30, subsection of Sale of Goods Act, provide that where a person having bought or agreed to buy goods obtains with the consent of the seller possession of the goods or the document of the title to the goods. The delivery or transfer by that person or by a mercantile agent acting for him of the goods or document of title under any sale, pledge, or other disposition thereof to any person receiving the same in good faith and without notice of any line or other right of the original seller in respect of the goods shall have effect as if such line or right did not exist. The related case is Newton's Wembley against Williams. Plaintiff, the true owner, sold the car to the first buyer. Payment was made by check. It was agreed between the parties that the title would only pass when the check was honored, but the plaintiff had given possession of the car to the first buyer. The first buyer subsequently sold the car to the second buyer, who in turn sold it to the defendant. The check was dishonored, and the plaintiff attempted to recover the car from the defendant. Held, the first buyer, who was in possession of the car with consent of true owner, could pass a good title to the second buyer, who in turn transferred it to the defendant. Plaintiff's action failed. He could only claim the price from the first buyer.
Application for this case is Eden should not have give possession to Danny before Danny have the owner title. The consequence of the action, Danny sell the car to the third party, Lisa. Lisa, who have buy the car with good faith, cannot return the car to Eden. However, Eden can use Danny for the price he sell to Lisa. Under Section 27, Chapter 1 of Sale of Goods Act, and the related case is Newton Wembley against William. Failure to pay the price, Danny may face the consequence. Conclusion for the case is no. Eden can claim his car because the third party, Lisa, has good faith. However, he could claim the price from Danny.